WESN.
Hello Trinidad and Tobago and those watching on the World Wide Web. Good afternoon and welcome to this special edition of Strictly Legal, where we will be joined by the guest of honor, the Honourable Attorney General of Trinidad and Tobago, MP for San Fernando West, the Honourable Mr. Faris Al-Rawi. He is here with us in studio and he will be giving us a lot of information on legal matters of the state. So we are pleased that you are joining us at WESN Content Capital, and of course you can watch us on the World Wide Web as well as all cable channels. So before I introduce the Attorney General, I just want you all to get some information as to what the Ministry of Legal Affairs and the Attorney General Office has been doing. Since September 14, 2020, the ministry was renamed the Office of the Attorney General and Ministry of Legal Affairs under the headship of the Minister of the Attorney General and Legal Affairs, the Honourable Faris Al-Rawi. And the AG has successfully managed the merger of three ministries, that is the Office of the the Office of the Attorney General, Ministry of Justice, and the Ministry of Legal Affairs. And this merger has saved the country billions of dollars, in which 532 laws, amendments, regulations, rules, and orders that were passed in 6 years under Mr. Al-Rawi. Mr. Al-Rawi has debated over 90 bills in the House of Representatives since 2015 to present, including the most prestigious Evidence Amendment Bill 2020 and the Whistleblower Protection Bill 2015. And there are so many things that the Attorney General Office has been doing behind the scenes. And of course, the AG is the head of the office and the legal advisor to the cabinet. So we welcome the Attorney General, the Honourable Faris Al-Rawi. Thank you and welcome to WESN-CC.
Thank you for having me. Good afternoon to Trinidad and Tobago. Great to be with you on the World Wide Web. Very much looking forward to providing some insight into how all of this matters to each of us. It's all well and good to have the responsibility and the title that goes with it, but people really want to know, what about me? Where do I fit?
Yes.
What is in the ride for me in terms of a better Trinidad and Tobago? And I'm pleased to shed some light on that.
Certainly, and that's why this program is called Legal Matters of the State. So everything state-wise, the Attorney General is here to answer. And Honourable AG, first of all, I must say congrats on your government's ability to pass unanimously the controversial, quote-unquote, Evidence Amendment Bill 2020. How do you feel about that passage of that bill?
The opposition support in the House was welcomed. It's unfortunate that they didn't support in the Senate. The law was a simple majority law, meaning the government could have passed it on its own. But if we were permitted the opportunity to use what we wanted, very critical piece of the law had to be removed from that bill, set aside, and that was something that matters with respect to the lives of witnesses. We're talking in Trinidad and Tobago about crime. We're talking about people's sense of security. We're seeing for the first time in a long time consistent, sustained public advocacy where people are peacefully pointing to issues and lamenting where they feel that there needs room, that we need room for improvement, etc. One of the issues inside of that is squarely the criminal justice system? Do I feel safe? Is the law working for me? Do I feel as if Trinidad and Tobago is a society that I want to live in and that I can prosper in? And one of the things that pull us down from that sense of security is the feeling that crime doesn't have a consequence. Now, we notice in the public domain, we notice the media in particular, pointing to the system. They say, fix the system. But what is the system?
And this is my question, because the criminal justice system for so many years have been touted as being in shambles. And of course, the evidence amendment, there is already an evidence act, and there have been several amendments to the said act. So what is different in this act, this amendment? Because the bill has, whether it has been passed, it has not been enacted, right? Because the president has to, obviously has to assent to the legislation. So tell us, what is different with this bill than the previous ones?
So I was coming to that bit about the system.
Certainly.
And one of the critical bits is that evidence is obviously the lifeblood of the criminal justice system. You can't have a trial without evidence. You can't have an acquittal without evidence. You can't have a conviction without evidence. We've had evidence laws in Trinidad and Tobago for 171 years. And we had some very archaic provisions in law which needed to be brought up to speed because there was an inconsistency in the application of laws. Let me explain this. Put this into the average context. We have in the criminal justice system this evidence, and the bill proposes a few things. The bill has been assented to. If I'm not mistaken, it ought to have been done already, but it needs to be proclaimed, and I'll come to that in a second. The position is that the evidence bill offers a change of rules that matter right now. It's something we've been working on for a number of years. A lot of consultation had to go into the process. And what this bill brings to life is, number one, it harmonizes the method by which people are identified at a police station. Right now, you have to go through the general rules of confrontation. You have to walk up to the person and tap them on the shoulder and say, hey, you're the guy. There's a sense of intimidation and fear, and then you hear stories about witnesses being attacked. This bill allows you one-way mirrors to identify people on a video mechanism, to have public place identification, but very importantly, what it does is that it video records when you get down after identification, when you get down to confessions or statements. We're having a live debate in Trinidad right now about whether the Police Complaints Authority can do the job to see what happened to two people who died in police custody.
Yes.
This bill says if you're going to interview these people, do it on camera.
Yeah.
And therefore there's no debate. Now this becomes necessary when you get to a trial. The first line of defense that comes up by somebody 10 years later, hopefully in 2 years later, as we now quicken the system, they beat the confession out of me, I didn't sign the statement, it was done. This law harmonizes that. Second thing this law does, it introduces CCTV camera evidence.
But does it harmonize it retroactively?
It harmonizes the law prospectively, so it is forward. It is to bring into effect the rules that have been established in the United Kingdom and the rest of the Commonwealth, and therefore going forward now, the requirement is that you will take these protocols strictly. You'll have a database where all things are loaded, so you no longer have the position of somebody saying, well, I lost my pocket diary, the station diary missing, somebody tore out the pages, the rats ate the evidence. That's a thing of the past if you formalize it this way. I was saying the second thing that the bill does, and importantly for people listening, it provides a backbone for CCTV evidence. Now, we're rolling out cameras everywhere in Trinidad and Tobago. License plate recognition, facial recognition, so that if a crime is carried out, you don't need to have somebody on the road come and tap you on the shoulder and say, I am the eyewitness that saw Rondell run over the person.
Yeah.
The CCTV evidence can speak for itself. This bill also, number 3, brings about protection for vulnerable witnesses. People who are victims of rape, people who are victims of abuse, children, they are all permitted now with special measures to protect them. They can appear remotely. Now, importantly, what this bill does not have, which is something that we were pushing for, but which we had to take out of the bill because the opposition wouldn't support it, is something called witness anonymity. Witness anonymity orders exist in New Zealand, in Australia, in the United Kingdom, in the United States, everywhere. You look at television and you will see on an FBI movie, a voice modulated and a screen blurred, and you wonder, hey, that looks good in Trinidad and Tobago. We don't have it. And it's not in the law because, unfortunately, we couldn't get the opposition to support that, even though in 2013, the opposition's policy for the amendments to the evidence bill specifically said, bring witness anonymity orders. So we're going to come with that again. We're going to ask the Honourable Leader of the Opposition to reconsider her position, because we started off on a question about how I felt about the evidence bill passing. So I'm warmed to see that the opposition has changed its course on this issue, and I'm hopeful. Again, the opposition has an important role to play in Trinidad and Tobago. I am obliged as a functionary in office to listen to the democratically elected government voices and opposition voices. I have no enemies in the opposition. I am obliged and I want to listen to what they have to say on the law, because it's for the peace, order, and good governance of Trinidad. So all that I'm asking is that they speak to the issues on the law.
But the opposition is stating that the passage of the evidence amendment bill, or act, is not sufficient to solve crime. Do you agree with that idea, or do you agree with their statement that it cannot solve crime?
So the opposition's objective seems to be to pour scorn on the systems that are in effect. Obviously, the evidence amendments aren't intended to operate in a vacuum. That's why I've consistently been saying that the formula that I have applied as Attorney General involves plant and machinery, people, processes, and law. So the evidence is part of the law. But this evidence amendment goes into 129 new courts which we've created. It goes into the criminal division which we've created, the family division which we've created, the children's division which we've created, the refining improvements to the civil, e-probate and other structures. It goes into raising the judicial age of retirement from 65 to 70, so we get 5 more years from our talented judges. It goes to giving full magisterial protection. It goes to creating a registrar in the magistrate's court where digital evidence is taken, so that you don't have a clerk at the peace running a court administratively longhand on a book. It goes with criminal proceedings rules, civil proceedings rules, family proceedings rules, children's proceedings rules. It goes with the fact that we went from 2 masters to case manage to 25.
Yes.
So these things all work together. And let me give you an example. While we were debating the evidence amendment on Friday in Parliament, while that was going on, the trial of the murder of Sean Luke, the voir dire, started.
And this is how much years after?
This is 15 years after. But hear this. That voir dire, which is where you challenge the evidence that's going to come before you start the trial, number one, it was before a judge alone, meaning no jury trial. We passed that law. Secondly, everybody appeared virtually and on camera. We put that into effect. The prisoners were in the prison, the judge was in the court, the defense attorneys were in their office, the prosecutors were in their office, and a witness, a critical witness to this case, a policeman who had retired, went to the United States, became an interstate truck driver, testified from on his phone in his cab of his truck on a pit stop. That could not happen prior to 2015 because of the judge-only law. We are the ones that passed it. The criminal proceedings rules came in under our watch. The criminal division, the ability to give evidence virtually was passed in 2016, 2017, 2018. The opening of the remand courts happened under this watch. We stopped moving prisoners from the prisons to the court, and in a 3-month period, for example, we did 15,000 appearances from the prisons, stopping the expenditure of $25 million in transport fees.
But then why that is all well and good, what about prisoners who have been in remand for over 10 plus years?
Absolutely. So let's treat with that. Remandees, significant condition. Justice delayed is justice denied, standard maxim of the law. People deserve their right and day in court, either to be acquitted or for the victim's justice in terms of conviction. For sure. You will recall that my first venture as Attorney General was to go into the public domain and do an expose on the prison system.
Yes.
The statistics I can tell you right now, we have 1,272 people on remand, incarcerated for murder as we speak. I can tell you we have 26,000 preliminary inquiry cases that are waiting to come to the court. I can tell you that there are usually 104,000 motor vehicle and road traffic cases, 8,500 marijuana cases. You have to know your data. Now, remanding. I want to let you know that we went to court to do two important matters. Following the decriminalization of marijuana
yes.
and following the COVID matters, I went to court as Attorney General and took a very novel approach where the state went and said, listen, we want to have non-violent prisoners come out under a couple of mechanisms.
And how many prisoners were that? Because I do recall during the COVID season that, well, I mean, we're still in the COVID season. However, I do recall early in the COVID session, that was something that the AG office had touted. But in terms of the numbers, I found that...
I want to read this. This is a letter from the Commissioner of Prisons to me, February 16th, 2021. February 16th. We're February 20th today. And at my request for information on statistics, rate COVID early release applications, the Commissioner of Prisons submitted the following information. For the period April 1st, 2020 to January 31st, 2021, the total number of convicted and remanded inmates discharged were 2,812.
And how many of
this
that was
figure
remanded?
is broken down.
Yes.
1,528 inmates bailed, with 101 females, 1,427 males. 1,284 under prisons remission for convicted inmates. If an inmate fine or arrears was paid, discharged from prison custody, 33 females, 1,251 males. This came about because of an application to the court. So whilst we want to shepherd the most violent people into no bail conditions,
yes,
we are at the same time looking at who is in the prisons, who is past maximum sentence, who can the benefits of applying the prison's rules work for. These are not insignificant statistics.
It's a lot, 2,000 plus. It's a lot of...
And I say that most respectfully to Mr. Seron Richards, who continuously says that this didn't happen. So this is the written correspondence coming from the Commissioner of Prisons.
And that is dated?
February 16th, 2021.
Honourable AG, we have to take a break and we'll be right back with more. And welcome back. You are viewing WESN Content Capital, and my guest today is the Honourable Mr. Faris Al-Rawi, Attorney General of Trinidad and Tobago. Honourable AG, we were speaking before the break, and I know during the break, we were speaking about how many cases would have been slashed due to the introduction of a lot of legislation and processes.
This I say in the context of communicating, thankfully through you, to Trinidad and Tobago to say, listen, there's hope. There's hope because there's a plan, and the plan is at work. This is no knee-jerk reaction to the excellent advocacy and public inquiry that's going on now. We're talking about things that have been implemented 2015, 16, 17, 18, 19, 20, and up to 2021. Part of the reason why people don't feel a sense of justice, and justice is delayed, is that there's a lot of grass inside the pipeline, and you need to move things out.
Yes.
Simply, you have 43 magistrates. We used to have 14 magisterial districts. And if you got a traffic ticket in Rio Claro and you're living in Scarborough or Roxborough, you had to find yourself in that court each time the matter calls. That's insane.
Yes.
You had a magistrate with limited immunity. The magistrate was operating with a clerk to the peace. The clerk to the peace would schedule matters in the court, no computerized system, no registrar, insanity. What do? We went and we looked at the statistics. You want quicker justice? Well, let's make sure that you have 3 divisions. We now have Tobago, North, South. Let's make sure any magistrate could hear any matter anywhere in Trinidad and Tobago. So that ticket in Roxborough could now be heard in Port of Spain or in San Fernando.
I think it's important for you to reiterate that.
Right? That means you don't have to travel by plane or by boat to get to the court and miss the date because you want to defend yourself. We then said, well, what does not need to be in the magistrate's court? You have 146,000 cases every year. What does that comprise? 104,000 motor vehicle and road traffic, 26,000 preliminary inquiries, 8,500 ganja cases, 2 spliff lockup cases. So what we did is we said, okay.
Only 800?
8,500.
8,000, oh, okay,
yeah?
8,500. Yeah.
What we said is, let's decriminalize marijuana, remove 8,500. Let's take motor vehicle road traffic offenses and convert them into violations. Let's give you a ticket in the mail and a demerit point, and let's, as a result, celebrate this year the lowest number of traffic deaths in 65 years in this country because of a speed gun and a demerit point system where people are rushing to make sure their tint is in compliance with the law for the first time in their lives. People are checking, boy, I get demerit points. But what that meant in terms of justice, 146,000, take away the 8,500, take away the 104,000. And when we abolish preliminary inquiries, you'll redistribute the 26,000 preliminary inquiry cases, only the summary matters will go in there. That leaves 43 magistrates in a virtual system, sitting anywhere, anytime, from a computer screen to deal with 16,000 cases max. That means that they can focus on domestic violence, they could focus on rape, they could focus on protection. But what we did further is we said, listen, it's inappropriate to have children inside an adult court. Children deserve the right to be anonymous. The best way to help the fight against crime is to take children out of conflict with the law. Why? Yes. You don't want to grow monsters. You want to protect your children. They may have been misled. And therefore, we created that children's court. And we have now added in drug treatment processes. There's a drug treatment court for children, a drug treatment court for adults. There's peer resolution. Now, all of this talk, AG, yeah, it's sounding nice, but what about me? I'm not seeing that. Trinidad and Tobago, there are a lot of ghosts still walking around because the old legacy issues are now coming forward. The Sean Luke trial is 15 years in arrears. The Piarco Airport inquiry going on 21 years, right? So those are the things that I call legacy matters. The intention that the government has as we bring in more judges now, as we open the criminal division by moving the civil courts from the Hall of Justice in Port of Spain, putting them at the waterfront and expanding the Hall of Justice to strictly criminal courts, we get to bring in more judges. And when you have more judges, you're able to tackle the backlog so that those ghosts disappear. No longer are 15-year trials the norm. You're going down to, remember, the civil division did a similar thing. When we passed the civil proceedings rules, there was pandemonium in the profession. People protest. Certain people who are now known members of the, no, it'll be the worst thing ever. A civil trial was 17 years in the making. It's now 1 year or 2 years max, as you know, because the judges have rules and sanctions. And if you don't comply, the matter is dealt with. Yes. We are headed there.
I know you have the consolidated civil procedure rules as well. H.E., we touched on the judiciary. Now, you've stated that there have been a number of courts that would have been, the judiciary would have been expanded, of course. Now,
over 1,000 new jobs in the judiciary.
No, I note that the judiciary has always been claiming that they are underfunded. Now, tell us if the judiciary has the capacity or the autonomy in terms of the funding from government to actually make these courts effective.
None of us have enough. We're in one of the most we're in the most difficult economic conditions. A country is not a company. A company has a balance sheet, a country has a balance sheet, it's called a budget. But in a company, if you need to balance your sheet, you cut expenses. It costs this country over $3 billion a month to pay salaries, wages, pensions, and bare basics. So we in a country must support the most vulnerable.
But then we're creating more jobs. How are we now?
We are creating jobs, but remember, we don't print money here. We earn money from our taxation.
Right.
Our taxation is our oil and gas take, whether it's supplemental petroleum tax, PPT, whatever form of taxation in the oil and gas industry, that's what we get. The revenues, as the Minister of Finance has demonstrated, we're nearly $2 billion short in this quarter. That means that the judiciary obviously has less available to it, as does the Ministry of the Attorney General or any one of the entities. So what we're trying to do is to do less with more. And let me tell you how we did that. We took 7 containers, shipping containers, put them in the prison, retrofitted them and put cameras inside and built out the inside. And voila, we opened a court. 15,000 cases in 3 months. So we're thinking outside the box in the meanwhile. And therefore, I want to compliment everybody who's trying to do more with less. And it's been tough. In the United Kingdom, the Prime Minister mentioned to us the other day, he saw on BBC, in Ealing, people for miles lined up in a line to go to a soup kitchen. So things are tough in the world, but we respectfully have so much that is going for us.
And so much to be thankful for.
So yeah, we need more. The innovation of transforming our economy will eventually take us to those positions. But in the meanwhile, we have to make this. And I really want to say that we have to start focusing on issue and good news. Because there's a lot of, I mean, I'm sure some of your listeners are probably saying, but where does fella get all of this stuff? What are you talking about? I never hear that. My case takes 6 years, 10 years. I know somebody. Yes, that's what was. The question is, where are we now? What is the road ahead? And what are the targets to get there?
Now, Honourable AG, let's switch to the Bail Amendment Act, or Bail Amendment Bill. Now, we have seen, and I was trying not to touch on it, but I believe it's important that we touch on it. For the last 2 weeks, I know you have been really busy, particularly in light of the Andrea Barath death, God rest her soul. Now, I note that as a result of the death, it seemed as though the government has been reactive in terms of tabling or quickly wanting to table a legislation to improve the Bail Act. Now, tell me more about it, because there's been a lot of opposition with respect to human rights being infringed. We've seen litigation with respect to a certain section of the Constitution and all these various things. So give me some more insight, or the public some more insight on this Bail Amendment Bill and whether or not the Cabinet or the government is actually going to table this legislation.
So, respectfully, we haven't been reactive to this because of that horrible tragedy, and my condolences to Ms. Barath's family. What we've been doing is continuing the work that we started. So I took today to the Cabinet certain recommendations for further review on the bail laws. I also took today to the Cabinet anti-gang legislation. I have also a number of other pieces of law in the pipeline, but these things were in the works for quite some time. We have a bill in Parliament right now to treat with improvements to the Police Complaints Authority. It's not reacting to the allegations that people have been killed in police custody. This was laid in December 2020. This came about as a result of work that has been ongoing. So the discussion on bail is a very significant one. Quite interestingly, I'm defending Section 5.1 of the Bail Act. Section 5.1 of the Bail Act was crafted in 1994. In 1994, the Bail Act came about, and what we did is we used the saved law to say there shall be no bail. You cannot access bail if you're on a charge for murder, very importantly. In the period 1994 straight up to this year, that has stood as the law. And very importantly, Mr. Ram Logan, Senior Counsel, Anand Ram Logan, is in court right now, having, as Attorney General, made bail restrictions born on the back of the strength of Section 5.1 of the Bail Act. Mr. Ram Logan is now in court, seeking to strike out Section 5.1 to say people on a charge for murder should be entitled to access bail. And he's asking for vindicatory damages for people who are incarcerated in remand without access to bail for murder.
Would you say access to bail based on discretion rather than automatic access?
So there is a, as we're well familiar, there is a principle of separation of powers. And it can be argued that the Parliament ought not to fetter the discretion of the judiciary, that would be an undue overstep of the boundary of the judiciary. That would normally, into the judiciary, that would normally be the case, save for the savings law provision, which is the pre-1962, pre-1976 Constitution, where these provisions existed as the law that was specifically maintained by the Constitution of the Republic of Trinidad and Tobago. This is the same reason why in Barbados you don't access bail in certain instances, or why they have put in other bail restrictions, etc. My point is, Mr. Ramlogan is entitled to be an advocate quite properly for any cause, but I find it difficult to understand how someone can accept a brief when the moral statements made on the parliamentary record in 2010, 2011, 2012, 2014, 2015 by Mr. Ramlogan were premised on the fact that he supported the strength and propriety of the bail restrictions in Section 5.1.
But then a lot of persons are stating that it's not a matter of bail restriction, or rather allowing criminals to roam free. But if there is enough evidence, detection, conviction, then there won't be needing to have persons on remand or forever.
I beg to differ, and that's because detection and conviction stand aside from waiting your turn in the queue in remand. So remand is where you're incarcerated, for the viewers, where you're incarcerated awaiting a trial. Yes. You are remanded into prison. There are many people who are remanded into prison who have been granted bail but can't access bail. And that's why that case I referred you to, where some 2,000 people who are beneficiaries of that, was important, right? But in the case of your most serious and most heinous crimes, knowing that we are fighting a battle in relation to gun violence, and we're fighting a battle in relation to murder, you got to think twice. It is in effect a form of deterrence in a carefully balanced situation. I don't want to go too far into the merits because it's sub judice right now, it's in the courts. But my point is, if ever Trinidad and Tobago needed to maintain its position on bail, it's right now.
Honourable AG, let's take a break. We'll be right back with more legal matters of the state. And welcome back, and you are watching WESN Content Capital with the Honourable Attorney General of Trinidad and Tobago, Faris Al-Rawi. Honourable Attorney General, we've seen a lot of opposition with respect to the capturing of license plates and their images, and that is the invasion of privacy, because everything is an invasion of privacy. Honourable Attorney General, what do you have to say about that?
That was very delicately and neatly put by you. What you meant to say is that Honorable Senator Saddam Hussein came publicly to say that he resisted the radio frequency identification move, where we change out number plates and make them detectable, on the allegation that it was a breach of privacy. So let's put this into context. What do you stand for? What does Trinidad and Tobago want? Do we want a safer environment? Well, crimes are committed, getaway cars are in existence, people are kidnapped in a car, they change out number plates, they're false plates that are put on. Look at poor Andrea Barrett. Yes. She did everything right. Yes. She traveled with a buddy, broad daylight, went into an H-plated car and suffered a tragedy. So that hits the nail on the head. We say, in part of our motor vehicle and road traffic amendments that we brought into effect in 2016, 17, 18, and up to 2020, what we did is we changed the rules. We made it in sections 20A, B, and C, new sections, a conditionality to use the road. And by making it a conditionality, I would tell Senator Hussein most respectfully, there's no privacy on the public road, sir. Okay. The public road is the public road. And
as an attorney, one would think.
In section 100 of the MVRT Act, we are permitted the ability to do regulations. And we have brought in and passed already the regulations to introduce not only spot speed, not only red light enforcement, not only demerit points, but RF tag IDs, meaning every single number plate in Trinidad and Tobago and every single vehicle will be issued by the government of the Republic of Trinidad and Tobago only.
But this is something that is done in other jurisdictions.
It's done everywhere.
So it's nothing
And
new.
what it does is that it allows now for these vehicles to be part of a network that can track where things have happened if law enforcement is looking at it. So when the traffic enforcement officer stops your car and just clicks your plate, it pops up, you know who the registered owner is, you know who the driver is, you know if the... By the way, we've tied in insurance to this already. So all of the database connections are in existence. And this forms a better Trinidad and Tobago from a security perspective. And I am at a loss to understand why somebody would want to oppose that. Because when they go and they take a trip to the United States of America and they rent a car, they happily sign the contract to say they'll pay the toll when the RF tag ID passes under SunPass or different things. I mean, come on. You can't want to be in the dance of reform in Trinidad and Tobago. Comply, you arrive in the United States of America, you don't ask a question, 4 fingers flat, thumb flat, picture flat. But in Trinidad, you want to fight about your right to privacy with respect to law enforcement. No, we need to do better.
The only privacy you have is in your home.
Yes, no, you have certain rights, your right to private life, to due process and things. Don't get me wrong. But on an issue such as this, surely we must see the merit in the reform of those systems. And by the way, we'll be doing an interim step that the Cabinet approved today with respect to the temporary issuance of plates, where they'll just be regulated so that we know who is able to issue plates. So you can't go and do like happened to Andrea.
And this doesn't have to be passed through Parliament.
We can do all of these things in the regulations that we brought to life already. We passed the law last year and in 2018. So these are not reactionary steps. These are things that are in existence already.
So is this a pilot project?
So it's not a pilot project. The request for proposals and public tendering went out for the person to issue, the entity to issue the RF tags. Those are now going to move into final stages. And in the meanwhile, while that system is populating, we have over 1 million cars on the road. So in the meanwhile, you don't want to have any and everybody fixing a plate. Well, you don't know where the plate comes, no proof of ID. Do you own the car? Are you an H plate? Why are you putting an H plate on a pickup? People, $200, give me my plate.
Yeah. And this will be mandatory across the board.
Absolutely. We have to take these small steps, make a huge difference. It's why people are now worried about whether they're going to get demerit points or if their tint is now working. In Trinidad and Tobago, that was a thing that you couldn't even contemplate. You remember when we introduced the speed guns into Trinidad and Tobago? People cried. They said, why did you change the speed limit? And we said, no, we didn't change the speed limit. We enforced the speed limit. It was always 80.
And that's the issue. Enforcement is an issue.
We changed it to 100. So my point is that these things that's why lowest number of road traffic deaths in 65 years.
Would you say that's because of COVID and the restrictions?
We had no restrictions for people driving on the road.
But there may have been less entertainment, less things to do.
Less
alcoholism.
Trinidadian hot foot is notorious. People had cabin fever. We didn't have a state of emergency in this country. We handled our situation so well that the head of the WHO said to the Honourable Prime Minister today, Mr. Prime Minister of Trinidad and Tobago, Dr. Rowley, well done.
And this was publicized.
This was global.
Yes.
This was WHO
and that's
saying,
the World Health Organization.
Congratulations to Dr. Rowley on his leadership.
And that says a lot about the government's approach to the management of COVID.
Well, I've been to court on umpteen matters in COVID. Set Ian Allen free. I'm COVID positive, release me from centers. Bar owners must open. Now, don't get me wrong, that's a hard blow for people, but now we're in a better place
and
where
exemptions.
at least we can have it. Yes, so my point is,
litigation.
This is not easy. It's easy to stand up as a person in office and talk about things. It's not meant to say that you don't feel with people. These are hard issues. You know the bars in San Fernando. you know, by Upper Hillside, you know, on Carib Street, you know, on Coffee Street, you
on
know,
Cipero Street.
Cipero Street, you know, as you headed down to Vista Bella, those fellas are hurting. I wouldn't go to the carrot shed because I get cussed morning, noon, and night, but I understand, I understand the pain. I understand the pain, and I feel with you. But when you're in authority and you have to take tough decisions, it's not done out of spite. It's so that you protect livelihoods and you protect lives. There are curfews and lockdowns around the world.
And of course, we've seen in the UK where they would have protected economy over life, and watch what happened.
Well,
now they are back into a lockdown.
They're now quarantining you.
Yes.
They are now doing what we are doing. And
we are supposedly third world. I believe we are first world in this.
We don't need a medal, and this isn't a glory factory, and this isn't all hail the Prime Minister. What this is look, some common sense and fortitude on the part of the Prime Minister, who is a scientist first and foremost, as a PhD in volcanology. That is what prevailed. Dr. Rowley has stood in the position of having to advise governments on whether to evacuate a country or not with volcanic eruptions. He's been where Dr. Parisram is now, which is why Dr. Rowley is so meticulously concerned to listen to the advice of experts.
Yes. Now, the Honourable AG, protection of women, pepper spray legislation. We've seen so many debates about pepper spray, the use of pepper spray, dating back to as far as I can remember. I must congratulate you for the first step in terms of Cabinet approving the use of pepper spray. What next? When do we expect the introduction of legislation?
So the National Security Council approved the use of pepper spray. As the Prime Minister had indicated, that was an exercise that was ongoing, because we were looking at the law enforcement perspective and the expert perspective. A number of countries don't authorize pepper spray because it can easily be turned as a weapon against you. That notwithstanding, the cry has been for a fighting chance. The National Security Council has agreed with that. They've passed it to the Office of the Attorney General. I've drafted the law. I intend to take it to the Cabinet, God willing, by next Cabinet, which is next Thursday, because we were scrubbing the cross-references. What pepper spray legislation will involve is an amendment to the Firearms Act. Because pepper spray is a noxious substance. A noxious substance is a prohibited weapon. A prohibited weapon is therefore a firearm.
So does one need a license to,
so you
to,
need
to
a
use
permit.
pepper spray?
You need a permit for pepper spray, but it doesn't start and stop with just the Firearms Act. It's not that simple. You want to criminalize people that use pepper spray in the commission of an offense. So you have to look at the Offences Against the Persons Act. You have to look at the Children's Act. You have to look at other pieces of law enforcement protection of officers. You want to make sure that you heavily criminalize pepper spray if you're going to use it against a law enforcement officer. You want to make sure that you have a prohibited class of persons. You can't just simply say any and everybody could get a permit for pepper spray. What about if you're on a rape charge with robbery and violence and kidnapping or trafficking in children? Surely you don't want any and everybody to have access to this.
And this is pepper spray use across the board. So it's not just for women.
There are men that are the subject of violence. And the issue of how you manage it for children is equally important. Our girls at 16, at 15 deserve a fighting chance as much as a 25-year-old woman or a young man. Now, I'm an advocate of martial arts. I've practiced it my whole life, grew up in it, taught it, believe in the concept of awareness. I want to remind you, any and everybody can hold a knife in their hand. Few people can use it. Your first defense is your sense of awareness, the sensibility of knowing, don't be at a particular place in a particular vulnerability. That takes us to people that do everything right and still become victims, like Andrea.
Yes.
Age plate, with her buddy, daylight, work to home. She did nothing wrong. That takes us to regulating other areas like PH taxis. But we're not, I heard in the papers some of the taxi men complaining and protesting outside the Ministry of Works and Transport. We are not regulating PH industry alone. It's every driver for hire. PTSC, taxis, maxis, checkered band maxis, which are coming for rural areas, fleet rentals, rideshare, and part-time hire, or PH, as I now call it, part-time hire. And in that system, what is intended is, if you're going to be somebody moving somebody for a fee, you're going to charge as a taxi would, you need to be en route. You need to know that this person is identifiable. So for example, as we're working it now, and I'm letting you into the working room now.
Yes.
This not having gone to cabinet yet, but we're far advanced in our discussions and fulminations. Imagine a Trinidad and Tobago where Faris Al-Rawi wants to be a part-time hire because I work during the day and I want to earn a little extra money. Well, I need to respect the taxi route because they bothered to comply with the law and to license themselves. I need to go and register myself, provide the information that the Motor Vehicle Authority will ask for as to the person and the car. The car needs to be roadworthy. It needs to be licensed. You then go onto an app and you go en route. And when you go en route, you put a light on the top of your car, like you see the cop cars in the movies, and you slap a siren on. Those are cheap and affordable magnetic devices now. You put that light on and you're en route. And then the person who's coming to flag you down meets a QCR code on the window or on the windshield or inside the car or all places. They put on the app and they just check the code. Automatically the app now tells you, yes, it's Faris Al-Rawi driving the car, it's number plate number so and so, and he's authorized. And then you even have add-ons that you could go to geo-positioning, following you, etc., etc. So this is where we're headed to.
Yes.
And we don't need forever to get there because we did the U-turn system. We did red light enforcement. We digitized all the number plates already. We digitized all licenses already. We have the system at work. We have red light enforcement about to go out in larger form. We have spot speed cameras. We have the RF tag IDs.
But what about the operationalization of the National Sex Offenders Registry?
So the National Sex Offenders Registry has been operationalized.
Because I've seen where there would have been
one
unofficial,
judgment,
but an unofficial registry that has been circulating.
Let's separate out the Sex Offenders Registry from the charges. So the Sex Offenders Registry is what we have in law. That says if you are convicted of a sexual offense and a judge says that you should go onto the register and you're incarcerated, or in circumstances where you may be put on a bond, etc., you have to go through certain assessment, and then and only then will a judge say that you have to go on the register. So we just had Justice St. Clair Douglas say that someone should go onto the register, but his name is not on it because he has to come out of prison first. And he has to go through a process of assessment before he comes out of prison. Now, why is it the sun, the moon, and the stars? The interest groups, and in particular the very strong women's groups, said that this is what was required because they were concerned about recidivism. They were concerned about people's names being ruined and their families being ruined. And they said to me, you're going too far, too fast.
But we've seen that with this unofficial list that has been circulating,
now,
and pre-action protocol letters.
This unofficial list is a very dangerous thing. Number one, rape simpliciter is a matter of consent. Is it yes or no? It could start off as a yes, turn into a no, and become a rape. And we all know that whilst there are many people that have been savaged, there's some people that have been framed. Yes. And currently, the framing doesn't carry anything more than wasting police time. So do we as a country now subscribe to an offense for setting up someone on a rape? Secondly, let's separate out aggravated rape, aggravated sexual aggression and kidnapping, sexual aggression and child trafficking, sexual aggression and breaking and entering, sexual aggression and larceny. Start putting those trespass. Those are very different from a boyfriend and girlfriend or people who know each other where a yes goes to a no. Those circumstances have to be met with the law. The preliminary inquiries law says that you can't publish pictures. So the person who has put out this register is in difficulty. Now, I've proposed and have already passed an amendment to that law, which is not proclaimed yet because it's in the indictable, it's in the abolition of PI law.
Yeah, yes.
And in that, we allow for the pictures to come. But right now, there's a national discussion that we have to have. Do we want to have a register of charges, but understand how
the
that
concept of innocence until proven guilty.
More than innocent, and the concept of ruining lives. the concept of ruining lives. So do we separate out the aggressive sexual aggression, kidnapping along with it? Is it lightning striking in a fork? It's not just one-shot rape. It's rape and kidnapping. So these are things that are not very simple issues to navigate and which we must have as a discussion in society so that we are not being reactionary in a knee-jerk, dangerous way, but we're taking, left up to me personally, I'm an advocate of the combined aggression formula.
But then, would that be considered part of the anti-crime, the cybercrime
Well,
legislation?
you've hit something that is very close to my, I've been looking at cybercrime trying to be passed for 9 years. Under Gary Griffith, he brought the bill as Minister of National Security, and I brought the bill as Attorney General, and we met the wall of the Media Association. The Media Association said, and I understand their point of view, that they did not want cybercrime to be applied to a journalist. Question, who's a journalist?
Because everyone is a journalist.
The guy who's blogging,
yes.
The people that weave and fabricate. Oh, geez, I was the victim of some cybercrime the other day where the UNC, they kick out the UNC page, who is Marissa Ram-Logan and a couple other people, if I've got their names correctly. Those people said to Trinidad and Tobago, they took a clip of me in Parliament and they cut it up. They cut off the bits where I was telling the opposition not to go and cry crocodile tears when they could come to Parliament and pass law. And they abused a lady named Tony Vincent. They abused her by putting this fake video, which she had some very strong things to say about when she learned the truth.
Yes.
She chastised them. But in that position, there was an abuse of, I have thick skin. But that lady who had to live with the thought that somebody who she put in office to do the work for she could be so heartless to say that. I mean,
and that's where the cybercrime legislation would have fit in.
Absolutely.
Honourable AG, before we go, time has fly really quickly.
I just want to be careful that I have not tripped, forgive me,
certainly,
anything defamatory. The kick out the PNM page administrators, as I'm told, subject to any correction, is Marissa Ram-Logan, Alan Karim, Asha Suknanan, and someone named Richard Ahmad. Right? And I just want to be careful that that's the information that has been given to me because it was hosted on their page. And I pray to God Almighty that they are not the ones to have committed that terrible aggression to a victim. And I don't mean me.
Honourable Attorney, plead the fifth.
Yeah, and we have a fifth. People don't know that. The right against self-incrimination is in Section 5 of our Constitution.
Correct. Honourable Attorney General, before we wrap up, I want to touch on the Tobago House of Assembly Amendment Bill. I know it's going to be tabling in Parliament tomorrow.
It's tabled already. It's to be debated tomorrow.
And tell us what do we expect? Do we expect opposition?
Well, let's deal with why the law is there. The law is there because everyone who is a democratic lover, somebody who believes in transparency, ought to hold the view it is inappropriate for an executive, like ministers, in this case, councillors in Tobago, who are still serving until a THA is appointed, to have charge of the public purse without the scrutiny of a Tobago House of Assembly. The government of the Republic of Trinidad and Tobago, let me repeat that, the government of the Republic of Tobago and Trinidad took the point of view, let the THA see if it can constitute itself. They tried 3 times. The election was on the 25th of January. We're now on the 20th of February. In those circumstances where they could not agree, and the standing orders specifically say how they are to choose a presiding officer, and then the presiding officer has a casting vote, and then the chief secretary gets sworn in, and the minority leader swears in, and all of the councillors who are serving as secretaries, they resign or fall out of office immediately when the chief secretary is about to take his oath, right? That couldn't happen. And in those circumstances, we went to the Tobago Autonomy Bill, where the recommendation since 2015 in the work in the public domain coming forward for Tobago's autonomy was take the number of electoral seats from 12 to 15. We went to the cabinet, I drafted the law is tabled in the parliament, it is to be debated tomorrow. It just does a few simple things. Number 1, move from 12 to 15. Number 2, upon the assent of that bill, the EBC has 3 months and no longer to define the boundaries. And the EBC has distinguished itself since independence and even prior as being an entity that is independent. So independent that an African state took our EBC in their march to independence to create their version there. That people don't know that.
Do you think that you will get the opposition support?
Well, we don't need it, most thankfully.
Simple majority.
I pray that the opposition would look at the issue. The issue is quite simple. It is unacceptable to have the Tobago executive still managing Tobago when the people have said 6-6. They need to go back to the polls. So this bill proposes change 12 to 15, let the EBC produce a report within 3 months, 15 seats are there, and then you call an election.
Honourable Attorney General, our time is up. But I want to thank you most sincerely on behalf of WESN Content Capital.
WESN, we pull a trick today. We have 2 South men on set. And I just want to thank you tremendously for giving me the opportunity to participate in your program and to speak to your listening public. And it's been a pleasure. And we will see more of you and your team. And thanks to your team. And all the best, Honourable AG. Thanks for the invitation. With you and the Attorney General Office. You have been watching WESN Content Capital, a special edition of Strictly Legal with me, your host, Rondell, and the Honourable Faris Al-Rawi, Attorney General of Trinidad and Tobago. Please be viewing, repeat at 8 p.m. Do have a great evening. Thank you for listening and watching. Bye.